So I'm going to record this bit for our friends who are not able to join, but they'll join later. So, welcome, gentlemen, to our May edition of the St. Paul Speaker Series. Today we have Mr. Victor Chilao, who's a Penta 1994, Rugambo House. He's currently an attorney in Lusaka, and he specializes in estate planning, business law, and other types of law that he's going to talk about. For this month's topic, we decided to focus on estate planning, and we gave him some things to talk about early on, but any one of you can ask questions regarding estate planning. So, understanding estate planning is how we prepare for the eventual passing, or even if that doesn't happen, how we prepare for conversing of our assets while we're still here. So it gives us an opportunity to have a say in what's happening, especially when we're incapacitated. So with those few words, Mr. Chilao, I think we'll let you take over. But one more thing, as part of introduction, Mr. Chilao is also the president of the Rotary Club of Nkwazi in Lusaka. So he's an all-round nice man. Okay, Victor, take it on, man.
Yeah. Thank you very much, Prof, for inviting me, giving me this opportunity to discuss with us estate planning. And I'll try and, as much as I can, to summarize whatever I'm going to talk about. I know I do have 30 minutes, so I should be able to stop at Zambian time 10 to 4. It's really a rare privilege to speak with all of us. I think the first thing that I would like us to do is that to define some terms. Estate, I'll start by defining estate. And estate means asset and liabilities of a deceased person, including those accruing to him by virtue of death or after his death. So the topic we are discussing today really has two sides to it. And I think we should concentrate more, and that's what I'd like us to do, on what happened when one is alive. And literally speaking, and because we are discussing this in relation to the law, I would like to state that in this country, the law provides for both customary law and statutory law. Put in another way, if a person dies single, they are still either, if they die single, they'll still be able to be subjected to the customary law or statute law. Whether one has one wife or several wives, they still be, they can still be, their affairs can still be taken care of by the written law. Having said so, there's also another term I think I would like us to define. Intestate. Intestate basically means that a person who dies without having made a will, and that includes a person who leaves a will but dies intestate to an extent that part of their estate was not included in the will. So there's a situation where a person would say they've got 4 items, they would write about how they want the 3 items to be dealt with when they're normal, and then leave out 1 item. So for the items that they would have included, the 3 items, they are called to have left a will. But for For the one item, they are said to have died intestate. And another item that we need to, or word we need to define for the purposes of this discussion is a will. Simply put, a will is a declaration as to what the person wants to be done with their estate when they are no more. So that's one definition also that we need to
I think we lost you there, Victor.
Sorry about that, gentlemen. Apparently, I'm using a phone as well. I'm using a phone for this discussion, and people that are trying to get hold of me. I do apologize about that. So, gentlemen, I have for us to continue this discussion. I would like you, and I would like us to reflect on a few things. What happens to your estate when you die? How are the problems or liabilities that you leave behind, how will they be dealt with? So these are the questions that I would like us to have in the back of our mind. It is, in my view, it is very, very important that as we grow, not only in years, but also as we start accumulating assets, it is very important that I keep on having these challenges, gentlemen. I was almost, I don't know, if this continues, maybe I'll use another means of.
Are you able to do not disturb on your phone?
Do not disturb. Yeah, let me try. We could go on a break. I remember seeing something like that before.
Okay.
Thank you very much for the guidance. Let's see. Oh, yes.
So while Mr. Chilao is doing that, in the chat, can you please just indicate your Penta? Because we've been collecting statistics on people coming, and we give an award at the end of the quarter. So last quarter, the person that won the award for coming to all events was Mr. Onward Lumbama. So the committee gives an award to the person who's consistent. So, yeah.
Thank you very much, bro. I've pressed on do not disturb.
Okay, thank you, sir. You can continue.
Are you assuring me that I won't have any call that you come through to disturb me? I don't know that function, Prof.
Well, just go on, man.
Okay. Yeah, so I was beginning to talk about intestacy, dying intestate. If we don't leave any instructions about how you like your assets to be dealt with when you are no more, at one's death, the law kicks in, the intestacy kicks in, and your assets and the liabilities will be distributed according to the law. This law has been with us since 1989. Before it, we were using the British Act. So what the Intestacy and Succession Act states is that at one's death, if they are married, first the assumption is that one would have been married, had children, parents, and dependents. So at their death, if they didn't leave a will, if they didn't leave instructions about how they would like their estate dealt with when they are no more, then the law will kick in and state that 50% of the assets must go to the children. Either that was a polygamous marriage or monogamous, but 50% go to the children. 20% go to the spouse or spouses. The other 20% goes to the parents of the deceased, and 10% go to the dependents. But like most of the issues, so if, for example, one didn't have a spouse, it means that the 20% meant for the spouse will be shared in the same proportions as I've stated earlier. Obviously, for you who know maths, you may say 5 to 2 to 2 to 1, something like that. So
I think we lost our speaker. I think when it comes
Maybe
back,
he needs
I'll
to
like
get on a different device.
I think so. You're right about that. He's coming back.
I was kicked out for whatever reason. Hello, are we?
You're good now. You're good.
Okay, thanks. Yeah, so that's what I was saying about the intestacy. The law kicks in and the distribution happens according to the law. But then also we need to know that there are a lot of qualifications. Who qualifies to be a dependent? Normally it must be someone who's below, I think that's 22 years old and they're in school. And also one who qualifies that more than 3/4 of their needs were being taken care of by the deceased person. And I was also talking about if the deceased left, say, 1 or 2 houses, the law provides that the surviving spouse should be able to get just 1 house, then the other one should be distributed. That is if either it is distributed to the beneficiaries or it is sold in order to pay debts that the deceased person could have left. I think generally that's about the intestacy in general. And now when we talk about testate, meaning someone who leaves instructions, someone who leaves a will, someone who really understands and appreciates that when they are no more, this property should go to this other person, or if my debts should go to this other, whatever way they want those things to be dealt with. That the first point of call is a will. And in a will, I must say that to start with, a will, or this generally must be in writing, a written instruction. But then also how it is written doesn't really matter. You can even write it in your local language. but your signature must be witnessed by two people that are present at the same time. And those witnesses may not necessarily know that that is a will. But if the person who prepares a will, or the author of the will, is called the testator. The testator can call someone or two persons and call them at the same time and tell them, there's this document that I have, and I would like you to witness. So he would sign, or you show them that this is my signature, then both of them sign present at the same time. That becomes a valid will. So generally, a will must be in writing and witnessed by two people, at least two people present at the same time. Number two, there are special wills. Such special wills are, say, for military people. They have gone to war, or they want to go, maybe when they're about to go to war, they're at war. They can just write or tell someone, I'll leave this is blah, blah, all those things. They would tell them like that. So that becomes some sort of a privileged will, a special will. But for this discussion, I don't want us to go that way, because we need to know way in advance that we need to give instructions about how we like our assets and liabilities dealt with when we are normal. But just to mention also that there are certain instances where someone would be on a bed in hospital. They can call a nurse and tell them, or whichever medical person is, or whoever is present there in the hospital, about how they want their assets to be dealt with when they are dead. And by the way, they must die from that particular ailment that made them be admitted in hospital. Then that will qualify as a will. One advantage of a will is that, one, the courts cannot tamper with what the testator wished for them when they are no more. And this means that if there are any alterations, they must be witnessed by the testator. If there are any alterations not witnessed by way of a signature of the testator, those are seen to be just like someone was fidgeting with that document. They wanted to alter it. The courts are only able to vary a will to a very small extent, assuming beneficiaries, ordinarily one of the beneficiaries was left out. So the courts do have a power, after being moved by that person who was left out, to allow for reasonable provision for them. You can imagine if you have 3 children, you distribute, or you say 2 of your children will be able to have part of your estate, whereas 1 is left out completely. So that person who's left out completely could apply to court, so that the court can do some sort of a variation, but to a very minimal level, because the wish there is, or the thinking is that the person or the testator knew why they distributed their assets in the manner in which they did. And that's the wish of a person who dies when they were alive, and therefore no one should tamper with their wishes. The other issue I think I would like to talk about should concern mostly our colleagues in the diaspora. I would like to state to you that even where you are, you can go ahead and prepare wills. As long as the will is valid where you are, and then if you decide to die, that will can still be used in this country The only process that would be required to be done is to reseal. Resealing of a will or probate is really to make an application in the High Court of Zambia, and that way, as long as the will was valid, of course, you're going to advertise in the newspaper and I think a government gazette. And after that, you even appoint the person that you would like probably to be executor or executrix. This is a personal representative that is going to carry out your instructions when you are dead. So you can just mention that, and then after the adverts, that document will be sealed in this country. Time seems to be running quite fast. What else is there to talk about a will? Oh, by the way, a will can be revoked. So there are basically three ways you can revoke a will. I'm sure you've seen, or I believe you've seen, where you say, I'm revoking all my previous wills. So basically you'd be updating it or just revoking it. You can do that. Then you can revoke also a will by writing a document to revoke a written declaration to revoke the area will. But the catch there is that your declaration, a written declaration to revoke a will, must be witnessed in a similar manner as when you're preparing a will, in a similar manner and procedure as that, where your testator is there with two witnesses present at the same time. Then the third part of revoking a will would be by destroying it. You can tear it, to shred it, you burn it. All those are ways of revoking a will. And by the way, a person must have the intention to create a will and must have the intention to revoke a will. There's that in Latin, I think it is called animus. Animus word. Oh, I can't remember. But you must have the intention. So if you just write a document without really intending it to be a will, that cannot be taken as a will. You must have the intention to make a will. Equally, you just have to have an intention to revoke. So there must be that, loosely speaking, I would create a guilty mind, which wants you to either to revoke or to have a will executed. I think I'm almost ending here. What I would like to state is that there are three types of people in this country or in the world. There are those people that leave instructions as to how they want to have their estate dealt with when they are normal. So meaning those that prepare wills. Number two, there are those that leave instructions, but instructions that are not complete. Maybe out of 10 properties that they have, they leave instructions about 8, then leave out 2, or vice versa. And there are those that do not have instructions at all, those that die intestate. Those are the three kinds of people that we have in this world and in this country. Then there's also another aspect of preparing for your estate, you're planning your estate. You could also choose to create a trust. And a trust has 3 parties. So you are creating to run on behalf of other people. And it's generally normal, especially for people that are above 40 and they've got property and they've got children, maybe the oldest could be 18 or somewhere there. So you could create a trust. And in that trust, you set out the parameters. You would say, okay, I have these 3 houses or maybe 3 houses or something. and you state that the beneficiaries, who are the children, should not sell this property till the youngest, say, is 25 or is out of university. Also, that's one way of planning your estate. And then you'd say, once the oldest reaches, say, 40 or 35, then they should fall off. Instead, one of their children, if they have a child, becomes part of the beneficiaries to this trust. And that way, it can revolve for a long time and without much problems. So you can get a guy just who runs the trust for you, and you pay them at the end of the month. Professor, maybe you may allow me to pause here in case there are any questions or points of discussion. Thank you.
Absolutely. Thank you so much, Mr. Chilao, for the high level description of estate and intestate and all that stuff. Very appreciated. So before we open up to questions, I have one, but it's very practical. So who are the estate planners in Zambia? Like, if somebody wanted to go to seek an estate planner, where do they go to? You're going to repeat everything you just said because you're talking to yourself right now.
Okay. Yeah, I was beginning to say that it's either I'm ignorant about estate planners, or people choose to go to lawyers and explain to the lawyers what they would like to have done for them. Then lawyers prepare an estate plan for them. So they either do a trust for them, a will for them, whatever it is that they can do for them. So I cannot point fingers to anyone, but I know generally that lawyers do prepare that for clients.
Wonderful. So lawyers it is. Okay. Gentlemen, the floor is open for questions.
Good afternoon, Professor. Afternoon, Council.
Mr. Makombe, welcome.
Thank you. Thank you. There has been, of late, wills being challenged in court. Do they succeed in changing the will to suit what the people that are remaining want to achieve or want to get that property? Thank you.
Thank you, Mr. Makombe. The law is very clear that there are certain ways that a piece of paper or a written document qualifies as a will. One such qualification is a signature by the testator, and the testator is a person that prepares the will in the presence of two witnesses. So if a party or a beneficiary or an interested party believes that that will was not properly executed, yes, they've got the right to challenge it. Do they succeed? I am not sure. Do they not succeed? I'm not sure. I don't have any statistics about that. But the fact that that exists, it means that yes, they become a conclusion at the end of the day to that to the challenges that may be getting into court.
For clarifications, Council, what I'm
Yes.
asking is, when I come to Council Chilao, I do everything, we register whether we need to register it, it's properly done. Can that
Yes.
will be challenged? And can those challenging the will actually be awarded
Yes.
at the end of the day?
No.
No.
No, they would not. The closest, like I said earlier, the closest success someone can have, and that's it. I'm using your example. If you came to our firm, because we know the requirements of preparing a will. So the moment we say, okay, this will is has qualified to be called a will. We know the only person that would successfully challenge that is a person that you, Mr. Makombe, would have left out unreasonably. Say maybe your firstborn daughter or son, you don't want to give them even one kwacha, and yet you have that money. So they can challenge that. And what the court will do, they're not going to change a lot of things. They will just ask, they will just provide for them just for something to sustain them, nothing more, just something bare minimum. Because the law assumes that the testator did not include this person for the reasons that he fully understood. And that can be for you leave out your spouse, your child, or whoever you ordinarily would have included. And what is at this, by the way, it's normally recommended that you don't have more than 2 wills. What I mean is that when you have your will, just get one, maybe you keep one with your priest or your bankers and your lawyers. Don't give it to a lot of people. The danger is if you print a lot of wills, beneficiaries in there may be happy or may be sad that you've left them with, you are promised to leave them with some property, so they can kill you. That has happened before. Thank you.
Yeah, just I have a follow-up question.
Yes, please.
Yeah, so a follow-up question on Makombe. So, as Makombe said, and we all know, you can write a will and be challenged, right? Is there a way of transferring assets to your children's names, but still maintain control of the assets? Because obviously, if I transfer to my son, it is his property, but I want to maintain control until I pass on.
Yes, there is. One of the ways is by way of a trust. So we create a trust for them. And then, and then we need to know that a child who's less than 18 years old, in fact, 21 years old, they may not have, they cannot have title to land. And what I mean by land, I mean building or just bare land. But you can create, you create something, say in trusts of Victor, such that when they're of full age, then you can transfer the title to them. But meantime, you create a trust where you say this property should not be sold. It still remains under Ephraim. It is not to be sold, but all the proceeds, if it's on rental or on lease, will go to my child. So yes, you can protect that. You have the full control over that.
Okay, so you've mentioned trust, which so I'm aware of the trust. But so is there no other way apart from, because obviously trust comes with the administering of the trust. So is the trust the only way? So if I transfer assets to a son, are you saying the only way of doing that is by trust?
No, but you can also use a will. In your will, would say property X is for Victor, but it won't become his once he attains the age of X.
Well, maybe I'm going around in circles, but the will, yes, says that. But as Makombe said, as you know, a will can be challenged. So my question was I transfer it, so it's in his name already, but somehow I maintain control, or is it? Do I just do that and not tell him? I guess that's where I'm looking at it from. Yeah,
strictly speaking, if you put it in his name and the title deed is in his name, so you are not the owner.
Okay. All right. Okay.
All right.
Mr. Chilao, there's a hand from Mr. Lumbam. Onward, please go ahead.
Council, I had written a question. I can't remember how we used to call it. The cover, not to sell. That cover, is it only the one who prepares the will, or other people can come in even after he dies, in case they see a danger of maybe an administrator or some confusion, so that someone anyone can come and apply, not to say.
Sorry, sir, I didn't get your question. You were breaking, I think.
Okay, sorry. I was saying, what's the cover not to sell the property? Are you getting me now?
Yes, I am.
Yes. The cover not to sell the property or property, is it only prepared by the one who is preparing the will, or can it be applied even after someone has died, and maybe either the son, when they see the danger of another person coming in to influence the selling of the property, does the two apply, or the other people can apply after the other person has already died, not to sell the property? Am I clear, Council?
Mr. Chilao is asking if it's clear. The question is also in the chat, so you can read that and answer. Well, we lost our speaker. I hope he has a will, you know.
And the trust.
And the trust as well. That was funny when you said, you know, and people know that you've left them the Mercedes Benz, when they'll take care of your end of life.
Quicken that process on your behalf.
Oh my God.
Sorry, I've lost. What did you last hear from me?
Well, so Mr. Lumbamad asked you a question. It's also in the chat. The question is the cover not to sell properties prepared by the person who prepares the will, or in case he dies, another person, either a son or administrator?
But where is that discussion coming from? There's a huge discussion somewhere.
Yeah, there's interference. I don't know where it's coming from. I think it's from Onward. Onward, mute yourself. Okay, thank you.
Yeah, so what I was saying is that any alterations must be made by the testator. He's the person, or she's the person that is giving out instructions about their property. And in that alteration must be witnessed by at least 2 witnesses. So when you talk about a son, it means that the testator would have died. So the son, at that point, if his one was appointed to take charge of those affairs, obviously they are also called the executor. If it's obviously the female is the executrix. So the moment those take up that position, they are stepping in the shoes of the deceased, and therefore they are free to make any changes to the will. And also, gentlemen, we may be able to know that we should avoid appointing people who would like to be beneficiaries of our estate, to appoint them as executors or executrix. The issue is, if they are a beneficiary and they are just 2, there must be always 2 people to witness. So if you appointed a beneficiary to be an executor or executrix, they may fall off unless there's a 3rd person, because the law, by the way, the law allows for 4 people to be personal representatives. So if you have got 3 or 4, that is fine, and 2 of which are executors or the beneficiaries, that becomes okay. But if there are just 2 of them, you may make that person lose out on their gift of their benefits, because they are part of the people that are implementing that which you wanted to be implemented. So they kind of become interested parties. Thank you. We may proceed.
Thank you, thank you. Mainga has a hand up as well. And then Chalo had a hand up as well.
Great.
Mind
Hi, good afternoon. Good afternoon, Council. I have a question.
Yes, please.
So let's imagine I set up a trust. To what extent can I continue to exercise some level of control over it while I'm alive? The reason I ask that is, look, let's say I'm still alive. I set up a trust for my children, but I'm still alive and I have assets, right? I obviously would want to, let's say if it's real estate, I maybe want to release some equity there to be able to do other things. You know, I get a loan against it. I use the security for something and I do other things. If it's in a trust, if I put those assets in a trust, am I still able to do that or is it locked away?
No, it's not locked away. It is not locked away because yes, you've created a trust, and in the trust deed, you clearly spell out your one thing. You clearly spell out what you can do with that trust. Remember earlier I was talking about you could say, so you set out the conditions with which your children would benefit from that. You would just say probably each child should get a benefit of just up to 10,000 kwacha, and yet the value of the trust is 150. So you would set parameters. So meaning you still have the control over that trust, because you are the one who's giving out. Those others are just beneficiaries. I don't know whether I've answered your question.
Yes, you have. Yes, you have. Thanks.
You're welcome.
Yeah,
Mine is more of a comment and maybe a question on the back end. It seems like there's a lot of gray area or cloudiness regarding the wills and how courts execute that, because one of the things that you mentioned was that if, for example, I left out my firstborn son for whatever reason, that can be challenged, because it almost seems like to me that courts reserve the right or the discretion to disregard my instructions if they can do that. And then the second part is, do you recommend, if I was to do a will or I did a will, do you recommend that that particular document be deposited maybe with a lawyer, or how do you recommend that we keep those documents? I mean, so to speak.
Thank you, Charlie. The first answer is that courts are nearly, in fact, they are reluctant. I would almost say they do not tamper with a will. That is the general rule, if you like. They don't tamper with that. However, the only times that the courts may vary, and this is to a very, very small extent, is when you have left unreasonable provisions for a person who ordinarily should have benefited. I'll still get back to the example of children. You've got 3 children. You give 2 of them whatever that you've given them, and then you leave out 1. So when they apply to courts for, loosely speaking, for a variation of the will, the court will have to find out what that child does. Let's say he's a CEO of some company. The courts will be reluctant to add in provisions for him because they can take care of themselves. But if it's someone who's more or less like an indigent, then the court would provide just something to sustain him for some time. So courts do not interfere with wills. Then as regards who should be a custodian of a will, normally it should be either your bankers, your lawyers, or your priests. And these must be people that are trusted. Like I've said, and history has shown us that sometimes beneficiaries kill the testators because they want to benefit that which they have seen in a will. That has happened even in Zambia several times. Someone says, okay, I'll leave my child with 3 houses and the other one with 1 house and blah, blah. Then the children try to kill their parents, and sometimes they succeed in killing their parents. So the fewer people know about your will and its contents, or in fact, the fewer people, yes, then the better for you. I hope I've answered your question, shall we?
Yes, you have. I've just removed the priest from that one because he might want to tithe out of that one, but that's a story for another day.
Okay.
Chalo, you have to pay tithe. Those are the rules.
I do. I'm just joking.
Then, Prof, before I forgot something.
Yes, sir.
The practice or what is obtaining on the ground is disturbing, alarming. All those, the matters that are at court, most of the matters that we handled as areas yesterday are for people that didn't leave wills. And this gentleman, I must say, without hesitation, that the way, let's talk about siblings. The way siblings behave before their parent or parents die is different from, generally, is different from the way they would behave when they are normal. And you do well to prepare a will or a trust. There are a lot of fights that happen, and not fights, okay, sometimes you even get physical fights, but also there are battles in court. That is not to say that we don't feel good, because then we get business. But if you can, please avoid, prepare wills. They work well for you. Thank you.
Okay, well, we're coming up on the hour, so I don't know how many more questions there are in the chat, but statistically, is it true in Zambia that if you prepare a will, you might die?
No.
Because, you know, there's hesitancy among us guys, you know, to just go down and write this stuff because people are like, oh, if I do this, I might die quickly, you know, that kind of thing.
That is a belief that doesn't hold water.
Yeah. But as part of, you know, financial literacy, these are type of things we should all be learning about very early on. And knowing that you can modify the will as you go on, as you add or subtract your assets or things like that is important. We didn't hear from the latecomers. I saw Sven came in towards the end. Do you have any questions for Mr. Chilao?
I'm a very late comer. Afternoon, gentlemen. I've just come in and listening to the concern about wills. I think something that we are concerned about is where to deposit these wills. I mean, normally you take them to a lawyer, but the lawyers are just as prone as we are to die at some point. I suppose their companies and organizations are well structured to still look after these wills. But I think this is something we need advice on. Do we take it to a lawyer? Do we put it in a bank vault if those still exist? Or where should we keep these wills?
For lawyers, generally that's law firms where there's just one lawyer, but the other law firms that have got. And in any case, if a legal practitioner dies, the Law Association of Zambia always appoints a caretaker of that firm. If it was a one-man law firm, it appoints a caretaker who takes care of all the files of that firm. And eventually the files are kept at the Law Association of Zambia. I know also that certain banks are able to deposit keep wills for Thank you.
Yeah, to your last point, Mr. Chilao, I've experienced with that. My older sister was a lawyer, and when she died in 2019, they appointed a gentleman to come and wind up her business. So all our clients were, kind of redistributed to other people, and their affairs were taken care of.
Yes.
Okay, very good. Yeah. So I think we've come to the end of the discussion, and Mr. Chilao, I'd like to thank you very much for talking about this very important issue, and hope many more people can participate in getting wheels done, because as you said, it makes for a smooth transition. I mean, all of us are going to become carbon at one point, so might as well just deal with it right now before that time comes. It makes it easy for siblings to handle the affairs of their parents when the parents are normal, and also just for the legal entity to handle everything that's going on. But one thing that maybe could tag along with this topic, Mr. Chilao, next time is to talk about incorporation of businesses. How do you separate yourself from a business? Because a lot of us are entrepreneurs, but our business are tied. We're sole proprietors. So if we die, our businesses die, or they get caught up in inheritance battles and all that stuff. So how does somebody separate themselves from the business so the business can be a running entity, as we've seen in other countries? So that could be another topic that we handle in the subsequent months. So unless there are any last questions, we'll declare the meeting closed and move on to just chit chats. Okay.
Okay. Obviously, yes, I can consider looking at that. We could discuss it at some point in the future. And I'd like to appreciate everyone, obviously, who has come to listen in, and I hope they've been able to get 1 or 2 points about what we've discussed. And it's been great talking to you and watching you. Yep.
Thank
Bye-bye.
you so much. Okay, gentlemen.
Before you close,
yeah, Lombe, go ahead.
can a video recording stand as a wheel? Or can it be a backup for the wheel? And maybe you explain why you've made a few changes here and there, and the way you prepared it.
That is very good food for thought. That's good food for thought. But as the law stands right now, no, a video cannot stand on its own. You can only use it for persuading the court. Because one thing is that what the court will look at, who kept that video, so there'll be a lot of questions asked about the media in which the video was kept, if it hasn't been tampered with. So there are a lot of those evidentiary rules that are allowed in order to admit something as evidence. On the face of it, that would not stand, because the law clearly states that it must be in writing and witnessed by 2. Unless it's a special will, which you have, maybe you're in hospital or you're in a battlefield, then that could stand. That's my response.
That's a good point, because we are all very impressed by our late President Manawasa when he had the video made before he died, and that was very persuasive in my view. Any more last questions? Okay. Well, gentlemen, it's Friday, and I'm sure it's about to be Friday in Jakarta, so we shall postpone this meeting to the next month. Our last Friday next month will be on the 24th. So with that said, thank you, Mr. Chilao, and thank you, gentlemen.
Thank you, gentlemen. Have a good weekend.
Thank you, you too.